Let's talk about the United States Supreme Court for a minute. Now, the United States Supreme Court is the highest court in the land. Now, what do? Well, they do a few things. One, they handle disputes between states. Now, what might states be arguing on? Well, for example, boundaries. A lot of states have their boundaries that they are done by natural landmarks. For example, in Iowa, both of our east and western borders are defined by rivers. So if something were to happen and the river were to change course or to change direction thanks to a dam or something like that, we could end up gaining or losing a little bit of ground based on the natural border of the river. Now there would be a dispute with whichever state it happened to affect, and they may say, well, we had that claim before, it should go back to the original boundary. And when there becomes a dispute like that, the Supreme Court would have to rule one way or the other as to which way the boundary should be, who's in charge of the disputed area, etc. Could also be who's in charge of dealing with issues involving the disputed area or the disputed boundary, and exactly where that boundary marker is. Like, is it the middle of the river? Is it a foot in? Is there a spot between, in the middle of the river where it's technically both parts of part of both states or whatever? That's one of the things that they do. There could also be issues with water rights involving, like, if we dam up a river upstream and now Missouri doesn't get any water from that river, or something, they may say, hey, we're going to sue. So that is one of the things that the Supreme Court deals with. The other thing they deal with is appeals. Now, when they handle an appeal, they look at the case and decide whether or not a law was applied correctly or whether a law was even allowable and whether or not the law was constitutional. Now, what does it mean to be unconstitutional? Well, that is where the Supreme Court decides, or a court in general decides, that a law goes counter to the Constitution. Well, what are some examples of something being unconstitutional? Well, I got a good one for you. Back in the 90s, Congress had passed a law granting the president the ability to line item veto certain things. So he would scratch out part of a law that he didn't like and sign the rest of the law into effect. For example, if there was going to be, $100 million going to go for some research project that he didn't want to spend the money on, he could cross that line out, write veto on that line, sign the rest of the funding bill, and the rest of the funding bill would take effect. Supreme Court looked at it and said, well, no, the Constitution clearly says that a president must either sign or veto the bill. And they read that as the bill as a whole, not separate parts and pieces, and said, no, you cannot grant the president a line item veto, and that would be unconstitutional. Now, how do you overrule a ruling of unconstitutionality from the Supreme Court? That would depend on what they're talking about. Now, if it is just, well, it's vague on this law, how it's written, or the way it's worded is unconstitutional, you could try rewriting the law to make it constitutional. That is entirely possible, depending on what they rule there. Or you could pass a constitutional amendment, amending the Constitution to make it so that thing is allowed or permissible. I have done another video in my Government Answers playlist talking about how amendments get passed. If you are unsure of how that process works, check out that video. But using my line item veto policy that we were talking about, should Congress want to grant the president that power permanently, what they would have to do is put forward a constitutional amendment granting the president that power, and it would have to go through the ratification process. If that amendment was ratified, then there would be a new amendment on the books, and the president would then have the power of a veto. So that is part of what they look at. What else do they do? Well, they look at, when they're looking at laws and things, they look at the complexity of the rights you already have. For example, under due process, they determined in the Miranda case that you, as part of having due process of law, you have the right to be reminded of what your rights are. So you look at they look like when you get booked and you get arrested, the police now read you your rights. They Mirandize you. They tell you you have the right to remain silent, that you have the right to an attorney. If you can't afford an attorney, one would be provided for you. They tell you that if you keep talking to the police, anything you say can and will be used against you. They tell you those things because the Supreme Court says they have to. Okay? Upon looking at other rights, there was Plessy v. Ferguson, which established separate but equal. That is how segregation came to be, because they ruled that as long as it was separate, as long as it was equal, that it was constitutional. Well, later on, the Supreme Court heard Brown v. the Board of Education and said, no, separate but equal is not okay. It does violate the Equal Protections Clause of the 14th Amendment. So Supreme Court cases can overrule each other. So those are some of the things the Supreme Court does. Now, what does it take to be on the Supreme Court? Absolutely nothing. All it takes to be a Supreme Court justice is to be appointed and then approved by the Senate. Now, does the Senate have to approve every Supreme Court nominee? No. Most recently, Anton Scalia died in 2016 in February. President Barack Obama appointed Merrick Garland to the bench. The Senate did not hold one hearing, did not confirm Merrick Garland. He did not become president. He did not become a justice. So, the Senate does not have to confirm anybody. Also, after the hearings they hold, that person may withdraw their nomination, say, you know what, I don't want to be considered anymore. That can happen. Or the Senate can deny that confirmation and say, no, this person is not right for the bench. So, if the Senate confirms somebody, they become a justice, they take an oath, and they become a justice on the Supreme Court. Now, how many justices are there? There currently are 9, but there is no constitutional limit to how many there can be. We have had 9 since, I believe, 1869. And at the time, there were 9 circuit courts. There has been some talk about expanding the Supreme Court to 13 justices to match the 13 circuit courts that we currently have. However, there is no requirement to do so. There is no constitutional requirement to do so. There has been at times as few as 6 justice seats allotted, and there has been at most 10. Now, I think they will always keep it an odd number because it is harder to get a tie with an odd number. So that's what I think. I think they are going to keep it an odd number at some point. Now, whether or not they need to expand up the court or not is a discussion that can be had at another point. And that would not require a constitutional amendment because the limit is not in the Constitution. However, they could pass an amendment and put a requirement in. That is entirely possible. They could also pass an amendment putting limits as to what it would require to be a justice. Again, there are no requirements as of right now. So those are a few things about the Supreme Court. I hope that kind of clears up any confusion that there may be about the Supreme Court and what they do, and how you get on the Supreme Court, etc. If you have any questions, drop a comment below, and I will try to answer them as best I can.